Good afternoon, everybody. Welcome to the Office of Tax Appeals. We're here for the consolidated appeal of HRA Highlander LLC and HRA Woodlake Village LLC. And before we get started, there's a couple preliminary matters I'd like to discuss and also make you aware that this hearing will be live streamed and available on OTA's YouTube channel. First, my name is Seth Elsom. I'm the lead hearing officer for this hearing. With me today is Administrative Law Judge Stephen Kim and Administrative Law Judge Asaf Clutter. While I'm the lead for the purpose of conducting this hearing, all three panel members are co-equal decision makers. Because this is a virtual hearing, it is being automatically transcribed verbatim. To speak, please unmute the microphone and remute the microphone when you're finished speaking to avoid feedback and background noise. To ensure that we have an accurate record, we ask that everyone speaks clearly and loudly. Please state your name before you speak one at a time, and do not speak over each other. After the hearing, the official transcript and video recording of the hearing will be part of the record and will be available on the OTA's website. Finally, as I mentioned before, please remember that these proceedings are being broadcast on our YouTube channel, and any information shared during this hearing will be heard and/or viewed by the public. And with that, are there any questions from either party before we begin? Judges, are you ready to go on the record? Okay. We are opening the record in the consolidated appeal of HRA Highlander LLC, case number 2403-15532, and HRA Woodlake Village LLC, case number 2403-15533. This matter is being held virtually before the Office of Tax Appeals. Today's date is Wednesday, November 20th, 2025, and the time is approximately 2:15 p.m. My name is Seth Elsom, and I'm the lead hearing officer for this appeal. With me today is Administrative Law Judge Stephen Kim and Administrative Law Judge Asaf Clutter. As a reminder, the Office of Tax Appeals is not a court. It is an independent appeals body that is staffed by tax experts and is independent of the state's tax agencies, including the Franchise Tax Board. And with that, I'd like to ask the parties to introduce themselves for the record, and we will begin with appellants first. Go ahead and unmute your microphone and introduce yourself, please.
Yes, my name is Sahar Bijan, and I represent the appellant HRA Highlander LLC.
Thank you, Ms. Bijan. And whoever's next Rohan, would you like to introduce yourself?
Yes, my name is Rojeen Bijan. I'm observing and also represent appellant HRA Highlander LLC.
Okay, thank you.
Samuel Brotman, and I represent appellant HRA Highlander LLC.
Okay, thank you. And I know that we had discussed in the pre-hearing conference that Brooke Stout may be attending, and it doesn't appear that she's here today. I'd just like to confirm that before we move forward.
No, she will not be attending.
Okay, thank you. And Respondent Franchise Tax Board, can you please introduce yourself?
Yes, good afternoon. Leo Cristobal, representing Franchise Tax Board.
Thank you, Mr. Cristobal.
Good afternoon, Alyssa Pinerbasi, also for Franchise Tax Board.
Thank you, Ms. Pinerbasi. Moving on to the issue. As confirmed at the pre-hearing conference and in my minutes and orders following the conference, there's one issue to be decided in this appeal, and this is whether appellants have established reasonable cause for the abatement of the per partner late filing penalty for the 2019 and 2020 tax years. Now let's discuss the admission of evidence. I'd like to start with appellants' exhibits, and as noted at the prior pre-hearing conference, appellants were provided the opportunity to submit their opening briefs as exhibits and agreed to, and those were numbered as exhibits 1 through 5 in our pre-hearing conference minutes and orders. FTB did not object to the admission of those items. And in response to OTA's minutes and orders dated October 19th, 2025, appellants submitted an additional 7 exhibits, which were listed by appellants as exhibits 6 through 12. The Franchise Tax Board was given the opportunity to object to those items or provide written objection to those items by November 12th and did not do so. And before I admit those items as evidence, I would like to clarify just a couple items regarding these submissions with appellants. Appellants, can you clarify whether HRA Opportunity One Fund is the legally registered name of the entity that is doing business as HRA Highlander LLC?
Yes, it is.
Okay, thank you. And second item was Exhibit 8, Exhibit 8 references HRA Woodlake's LLC's e-file authorization form for the 2019 tax year, but it does not appear to be in the submission. And I just wanted to clarify whether you intended to submit that item or if there was a reason that was missing, if you can clarify what happened there.
I think if Regine, could you please clarify that?
Yes, sorry, we included the name because we asked the client to provide us with that document, but they were unable to locate it, so that will not be admitted.
Okay, thank you. And FTB, I just wanted to quickly check with you to verify that your non-response to the minutes and orders is correct and you still have no objections to the admission of exhibits 6 through 12 and the admissions of exhibits 1 through 5.
Yes, this is Leo Cristobal. That's correct. FTP has no objection.
Okay, thank you. Exhibits 1 through 12 are now admitted into the evidentiary record. And now we'll move on to the Franchise Tax Board. Franchise Tax Board, you've submitted 17 exhibits, which have been labeled as exhibits A through Q. These exhibits were submitted by the Franchise Tax Board prior to the pre-hearing conference. Appellants, were asked to review these items and indicate in writing whether they had any objection to the admission of these items into evidence. Appellants did not provide any written objections to OTA. And Ms. Bijan, I wanted to clarify again with you, is that still the case? Are there no objection to the admittance of these items into evidence?
Yes, there's no objection.
Okay, thank you. Exhibits A through Q are now admitted into the evidentiary record. And because moving on to witness testimony, because Ms. Stout is not attending, it's my understanding that there will be no witness testimony today. Is that correct, appellants?
Correct.
Okay, thank you. Finally, before appellants begin their presentation, I'd just like to briefly discuss the order of the hearing. As noted in the minutes and orders, appellants will present first and will have approximately 30 minutes for their presentation. Following appellant's presentation, Franchise Tax Board will have the opportunity to ask appellants questions regarding appellants. Excuse me, we do not have testimony, so I'll correct that. The panel will then be given an opportunity to ask questions they may have for appellant. Following that, FTB will have 15 minutes for their presentation, and I will again turn it over to our panel for any questions they may have of FTB. Finally, appellants will have an additional 5 minutes for rebuttal or closing statement, and then I will again turn it over to the panel for questions of either party. Before we begin, does either party have any questions?
No.
Okay. We're going to begin appellant's presentation. You have 30 minutes and the time is approximately 2:24.
Thank you. Your Honors, thank you for the opportunity to present our position today. Penalties are intended to encourage voluntary compliance, not to punish taxpayer or serve as a revenue-raising mechanism. FDB Notice 89-586, consistent with IRS Policy Statement 20-1, makes that clear. This case shows why the penalties here do not serve that purpose. This is not a situation where the taxpayer ignored their responsibilities or tried to avoid filing requirements. For more than 20 years, my client has met every state and federal filing obligations on time, even during the unusual and challenging tax years of 2019 and 2020. They followed the same responsible process they had always followed. They closed their books on time, provided all records to their CPA in January, signed the e-file authorizations, and paid their taxes well before the deadlines. All taxes were paid on time, and the state suffered no harm whatsoever. They had every reason to believe their returns had been filed, and they received no notice that the CPA's file submissions were rejected during the height of COVID-19 disruption. The late filings were caused by an e-filing failure on the CPA's end, something entirely outside of the taxpayer's control. And this was a single isolated event in an otherwise perfect compliance history. Imposing penalties here does not promote voluntary compliance. It simply punishes an otherwise compliant taxpayer who acted responsibly for over 2 decades. For these reasons, we request abatement based on reasonable cause. So, Your Honors, the issue for the panel's consideration is whether appellant's late filings for 2019 and 2020 California tax years should be executed under the reasonable cause exception as defined by the ordinary business care and prudence standard. I respectfully submit that under the unique and extraordinary circumstances of COVID-19 pandemic, the appellant's actions not only met but exceeded this standard, and the penalty should be abated. To guide the panel, I will briefly summarize the applicable standard. Under Revenue and Taxation Code sections 19131 and 19132, penalties must be abated when a taxpayer shows that the failure to file and pay was due to reasonable cause and not due to willful neglect. OTA decisions interpret reasonable cause to mean that the taxpayer exercised ordinary business care and prudence, and the burden is on the taxpayer to show that an ordinary prudent business person facing similar circumstances would have acted in the same way. This is an objective fact-specific inquiry. The OTA must evaluate the taxpayer's conduct by comparing it to what would be expected of a reasonable business person facing the same circumstances, not simply what the particular taxpayer thought was sufficient. With that framework in mind, Your Honors, I will turn to the relevant OTA case law. In appeal of J. Fisher and M. Fisher, the OTA denied penalty abatement because the taxpayers failed to provide adequate records, relied on their preparer, and did not personally verify that the return had been transmitted. Fisher was decided in a normal tax year, and the OTA compared the taxpayer's conduct to what a prudent business person would have done under ordinary tax year circumstances, where systems and professionals were operating without external disruption. Because the circumstances were routine and not marked by widespread delays, closures, or systemic strain, the OTA held that a prudent business person would have verified the filing and that reliance alone was insufficient. My client, like Fisher's, relied on their CPA and did not personally verify the transmission. But unlike Fisher, my client provided all records timely, signed the e-file authorizations, paid the taxes early, and has contemporaneous documentation showing diligent at every step. By contrast, Fisher involved an ordinary tax year with stable operations and a predictable filing system. My client's filing occurred in the middle of COVID when remote work, system failure, staff shortage, and widespread disruption fundamentally altered how the businesses operated. A COVID year filing cannot be evaluated under the same expectations as an ordinary year. The similar circumstances standard requires a meaningful comparison, and the circumstances here were not comparable to those in Fisher, and in fact, in any other cases. Your Honors, the next case that guides this analysis is the Tupper decision. In appeal of N. Tupper and J. Tupper, the OTA denied abatement where the taxpayers had to sell stock at the last minute because they had not reserved cash or made any argument for timely payment. The OTA held that a prudent business person would have anticipated the obligation and planned ahead, and that the taxpayers' last-minute scramble showed a lack of preparation. Our case is the exact opposite. There was no failure to anticipate, no failure to plan, and no last-minute scramble. My client completed everything weeks in advance, provided accurate and complete information to the CPA exactly as they had done for 20 years, and they paid the taxes by the deadlines. Under normal circumstances, they would follow their regular practice and check with the CPA to confirm that their returns had been filed. But once COVID hit, the circumstances shifted dramatically. Their attention was diverted to employee safety, remote operations, unstable communication and internet systems, intermittent staff illness, and emergency public health directives, as reflected in their COVID office procedure email in Exhibit 10. In that environment, the business was operating under extraordinary strain, unpredictable conditions. It was entirely reasonable and consistent with 2 decades of flawless compliance to rely even more heavily on the CPA with a perfect 20 years of track records. That reliance was grounded in experience, not neglect, and it stands in a stark contrast to the lack of preparation seen in Tupper. Turning to the next relevant decision, Your Honors, the Smith's case offers a useful contrast. In appeals of N. Smith's, the OTA rejected a general COVID hardship claim, stating that the taxpayer provided no specifics, like no illness, no incapacity, and no continuous obstruction that actually prevented filing. The decision made clear that hardship must be substantiated and continuous. Smith's also involved no evidence of long-standing professional relationship or any history of consistent compliance, leaving the OTA with no basis to find that reliance of the preparer was reasonable. Our facts are similar to Smith's only in that the filing period fell squarely within the heart of COVID, when the pandemic itself created the hardship. But unlike our case, Smith's offered no evidence of actual COVID-related disruption and therefore never raised the argument we are making here, that the pandemic conditions themselves made the ordinary circumstances standard inappropriate. Because that argument was never before the OTA, the panel had no occasion to question its use of ordinary circumstances framework in the Smith's. In our case, by contrast, we're presenting the type of concrete COVID-related circumstances that the Smith's never offered, making this the proper context for OTA to recognize that the ordinary circumstances standard does not fit the realities of the pandemic period. No ordinary circumstances ever existed where remote work was forced overnight, with employees and employers who had no prior experience with it. No ordinary circumstances existed before where e-file systems were unstable and communication was unreliable. And under no ordinary circumstances were taxpayers expected to manage unprecedented, unnecessary uncertainty while focusing on basic health and safety. In addition to these challenges, people had to deal with balancing family responsibilities at home, while simultaneously adapting to entirely new working conditions. The CPA's filing failure occurred in such extraordinary environment because of genuine operational disruption, not a vague or generalized hardship. And like their CPA, my client too had to deal with operational disruptions. And unlike Smith's, my client had a 20 years relationship of flawless compliance with the CPA. That proven track record created a reasonable expectation that the CPA would handle the filing properly, especially during a period when prudent business owners were prioritizing staff safety, remote operation, and relying even more heavily on a long trusted professionals. My client had no reason to suspect the filing would be mishandled after 2 decades of perfect compliance. There are emails confirmations and contemporaneous communications showing that the CPA told the taxpayer the filings were in process. For example, on March 15, 2021, the appellant sent a follow-up email to and received an email confirmation from the CPA stating that they were diligently working on the 2020 tax returns and expected to file them on the deadline, if not earlier. And that email is in Exhibit B. When the FTB notices arrived, the taxpayer immediately investigated and CPA admitted their fault in writing. Unlike Smith's, this record shows a taxpayer who took every reasonable step within her control. The OTS similar circumstances standard presumes the existence of comparable past situation that defines what a prudent business person would do, including ordinary illness, typical business disruptions, agent error, or financial hardship. But COVID-19 was not a comparable circumstance. It was a global government-mandated shutdown. There is no prior event in the modern era with the same breadth, duration, or impact. There is no historical baseline of what ordinary business care and prudence looks like during a global pandemic of this magnitude. And because the OTA's objective test asks what a prudent business person would do under similar circumstances, the test cannot be meaningfully applied when no similar circumstances have existed. The OTA's prior cases, Fisher and Tupper, both involved ordinary tax years. None of them involved the chaos, systemic breakdowns, and operational disruption characteristics of 2019 and 2020. Applying their ordinary year analysis to COVID year filing disregards the factual reality of this period. Smiths did not present the central point we're raising here. The point that we're raising here is during the height of COVID, the pandemic itself was the hardship. The disruption, uncertainty, and operational instability were so widespread and unprecedented that a taxpayer should not have needed to show illness or individual incapacity to establish reasonable cause. In other words, the extraordinary pandemic conditions were the very obstacle to timely filing. For these reasons, to satisfy the purpose of Revenue and Tax Code sections 19131 and 19132, the reasonable cause standard must be applied in a way that acknowledges the uniqueness of COVID-19. Reasonable cause is established when a taxpayer did everything within their control, acted consistently with 2 decades of perfect compliance and relied on a CPA whose failure occurred during unprecedented operational disruptions. Thank you.
Thank you, Ms. Bijan. Does that conclude your presentation?
Yes.
Okay. I would like to turn it over to my panel now for any questions they may have of appellants. And we'll begin with Administrative Law Judge Stephen Kim. Do you have any questions for appellants?
I don't have any questions at this time, thanks.
And Administrative Law Judge Clutter, do you have any questions for appellants?
Yes, I just have one question. Ms. Bijan, I noticed that you referred to our appeal, our precedential appeal, appeal of Fisher. And in appeal of Fisher, it mentions that every taxpayer has a personal non-delegable obligation to ensure the timely filing of a tax return, and thus reliance on an agent to perform this act does not constitute reasonable cause. Can you please address that statement? Thank you.
Sure.
Sorry, do you mind repeating your question?
Oh, sorry. There was a reference and comparison to appeal of Fisher, and in appeal of Fisher, there's a statement. Let me back it up and say that I understand that in this case, there is a late filing penalty that was imposed, and if I understand correctly, appellants are asserting that there was reasonable cause, and that justifies abatement of the penalty. And the reasonable cause relates to reliance on a CPA. And then there was discussion of Fisher. So in Fisher, there is a statement that reliance on an agent to perform the act of timely filing a tax return does not constitute reasonable cause. So I'm just wondering what you make of that statement, what your response to that statement is in appeal of Fisher.
I think that there are moving parts to that statement as to what reasonable cause means, and the standard that we use and the non-delegable duty. I think that it shouldn't be a bright line rule, especially in the context of COVID. And when the standard is applied to the COVID era, it can't be comparable. Yeah.
Thank you so much.
I
And
have,
no further questions.
thank you, Judge Clutter. I had just a few questions for appellants, and the first would be, can you please spell the names of the cases you cited other than Fisher? Spell those and provide the case numbers for the record.
Sure. So one was appeal of N Tupper, which is T as in Tom, U, P as in paper, P as in paper, E as in Edward, R. And the case number version, do you have that?
Yes, the case number is 230212644. And then the other case was Smeets.
Yes.
SMEETS, case number 221011617.
Okay, thank you. And I had one question just related to the operation of the tax preparer during COVID. I know you'd provided some email correspondence of the disruption that this caused and work from home requirements, et cetera. Is there any specific event that you can show that was caused by COVID that prevented the filing of the returns, or is it just COVID in general, the effects of the pandemic in general that you're asserting caused the delay in filing the returns? Either one of you can answer.
Sorry. I would say it was all of it. The remote working, having to care for your employees, get them set up for remote work. There was a lot of moving parts during COVID. So I wouldn't say it was one single isolated event that caused the late filing. I think it was all of the moving parts that we all felt as well, because we lived through that period of time too.
Okay.
Your Honor, is moving into specifically what the taxpayer was dealing with. I know COVID has been many moons ago for all of us, but if you think about this, the 2019 return, the initial filing period was in March of 2020. And in March of 2020, all of us were sitting here wondering if it was when the governor came on the radio and on TV, shut down the state of California. COVID was still very new. It was still very fresh. It wasn't like when we all got used to COVID. This was a time where everybody was scared, where there was a lot of panic, there was a lot of misinformation. And then as you move through 2020, particularly getting into the third quarter of 2020, this is when the Delta variant occurred. There was a lot of change in regulation. There was a lot of harm caused to the CPA community because the FTB was not in the office. The general assistance lines were down. The ability of preparing returns, getting e-filed, the normal tax preparation process was anything but normal during that period of time. And then the guidance that was coming out was consistently late. So the disruption caused to CPA firms and to Brooks CPA firm, it really can't be understated for what had happened. I mean, we're dealing with a once in a lifetime event that caused a massive and significant disruption. I mean, communications were down. We all remember what it was like. It was just difficult to be able to communicate each other, especially for a process that requires people to be in the office to collaborate, to do due diligence, to go through the checking process. I mean, how could they not have been disrupted? I mean, this penalty is really about tax compliance. And, it's different than the other cases, because given the circumstances, you're talking about a 20-year relationship that was disrupted by a once in a lifetime event. I mean, if you don't have a variance for those that big, what constitutes reasonable cause in this case? We understand the need for tax compliance. We understand why the FTB needs returns filed on time for the verification and enforcement processes. But I mean, objectively, this was something that is just completely unprecedented. And if this doesn't qualify, I don't know why these penalties exist. Or I don't know why there's an abatement protocol that exists other than these circumstances. So there's got to be a sliding scale, and how we look at what reasonable cause is and how we look at behaviors and actions of taxpayers and their representatives, it has to be judged by looking at the facts and looking what was going on in this period of history, which we all remember is very vivid for the rest of us.
Okay, thank you, Mr. Brotman. Was there anything else appellants would like to add before we begin the Franchise Tax Board's presentation? I'll take that as a no. Does that conclude your presentation, appellants?
Yes.
Thank you. Thank you for your presentation. We will now turn it over to the Franchise Tax Board to begin their presentation. You have 15 minutes for your presentation. The time is 2:50 now, and you may begin whenever you're ready.
Great, thank you. Good afternoon. As I mentioned, my name is Leo Cristobal, and I represent Respondent Franchise Tax Board, or FTB. As has been mentioned, the issue in this appeal is whether appellants have met their burden of proof to establish that their failure to timely file their 2019 and 2020 tax returns was due to reasonable cause. Appellants are limited liability companies, or LLCs, that were required to file California tax returns by the 15th day of the third month following the close of their taxable year. However, appellants filed their tax returns late, as their 2019 and 2020 returns were not filed until July of 2022. Since all four tax returns were untimely filed, FTB imposed per member late filing penalties as required by law. When FTB imposes these penalties, the law presumes the penalties were imposed correctly. And to overcome this presumption, taxpayers bear the burden of providing credible and competent evidence in support of a claim that the failure to file timely was due to reasonable cause. To establish reasonable cause, taxpayers must show that the failure to file on time occurred despite the exercise of ordinary business care and prudence. Ultimately, the reason for missing the deadline must be such that an ordinarily intelligent and prudent business person would have acted similarly under the circumstances. Otherwise, the penalties will not be abated. In this case, appellants have stated that they had no reason to suspect error. They highlighted their trust and longstanding relationship with their CPA and asserted that the CPA's oversight is what was primarily the reason that the returns were filed late. Appellants have also cited the COVID-19 pandemic as part of their attempt to demonstrate reasonable cause. Unfortunately, notwithstanding the impact that COVID-19 certainly had on individuals and businesses, the successful filing of appellants' tax returns did not occur until July of 2022. In total, their 2019 returns were 28 months late, and their 2020 returns were 16 months late, respectively. Notably, during these 28-month and 16-month periods separating the date appellants' returns were due and the date the returns were filed, appellants have not sufficiently demonstrated how the pandemic consistently prevented them from fulfilling their duty to file their returns on time. Additionally, notwithstanding appellants' reliance arguments, it is important to note again that there is a well-established right-line rule stating that taxpayers who rely on tax advisors or agents still maintain a personal, non-delegable duty to timely file their tax returns. It requires no special training or effort to ascertain a deadline and make sure that it is met. Consequently, appellants' ultimate failure to timely file cannot be excused by the reliance on their CPA, as such reliance does not amount to the kind of reasonable cause required for abating late filing penalties. Furthermore, precedential OTA case law has held that ordinarily intelligent and prudent taxpayers using e-file technology would have sought to obtain e-file records showing that a return was transmitted, received, and successfully accepted by FTB. In contrast, the evidentiary record in this case does not show appellants attempted to procure records confirming that their tax returns were successfully accepted by FTB by the filing deadline. Moreover, the OTA has held that taxpayers' actions do not establish reasonable cause for late filing when they choose to rely solely on the representations of their tax return preparer. This case has been mentioned, but in Fisher, the OTA found that the taxpayers received confirmation from their tax preparer, notifying them that their returns had been filed. However, the OTA in that case held that the exercise of ordinary business care and prudence required appellants to personally verify the return had been successfully transmitted, and when it had not been, to take appropriate corrective action. The OTA reasoned that although the taxpayers intended to meet their tax obligation, when the taxpayers chose to rely solely on the representations of their tax return preparer that the return had been filed, those actions did not establish reasonable cause for late filing of the California tax return. In this case, appellants delegated the filing of their returns to their CPA and stated they had no reason to suspect error. Similar to the taxpayers in Fisher, appellants relied on their CPA and argue that when they followed up, they were assured that the returns were filed. Like those taxpayers in Fisher, appellants chose to rely solely on the representations of their tax return preparer that the returns had been filed. However, as held in that precedential opinion of Fisher, the exercise of ordinary business care and prudence required more of appellants, in that appellants needed to personally verify that the returns were successfully transmitted to FTB. And unfortunately, again, notwithstanding COVID-19, that is not what appellants did in this case. Instead, there is no evidence of timely, successfully accepted submissions of appellants' 2019 and 2020 California returns to FTB. And it is undisputed that the relevant returns failed to be submitted on time. In conclusion, appellants have not met their burden of proof to establish that their failure to timely file was due to reasonable cause. Therefore, appellants are not entitled to penalty abatement, and FTB's action denying appellants' claims for refund should be sustained. Thank you, and I'm happy to answer any questions you may have at this time.
Thank you, Mr. Cristobal. And I would like to turn it over to the panel now for any questions, and we'll begin with Administrative Law Judge Stephen Kim. Do you have any questions for the Franchise Tax Board?
I have no questions. Thank you.
And Administrative Law Judge Clutter, do you have any questions for the Franchise Tax Board?
No questions. Thank you so much.
Okay, thank you. Thank you for your presentation, Franchise Tax Board. We're now going to turn this over to appellant for their closing statement or remarks. And appellants, you have 5 minutes. You may begin whenever you're ready. Ms. Bijan, you're muted.
My apologies.
Thank you.
I will now conclude by summarizing the key reasons why reasonable cause exists. My client timely closed their books, provided complete information, signed all authorizations, and paid all taxes well before the deadline. They had every reason to believe their CPA, who had a flawless 2 decades track record, successfully filed their returns, and they received no indication otherwise. The only failure was the CPA's undisclosed e-file rejection, an event entirely outside of the taxpayer's control and occurring during the most disruptive tax administration period in modern history. Penalties are not meant to be punitive. When the taxpayer paid every dollar of the tax on time and the state suffered no harm, imposing penalties serves no corrective purpose and does nothing to promote voluntary compliance. The standard of ordinary business care and prudence cannot reasonably be applied to a period when nothing about business operations or life itself was ordinary. This standard presupposes a stable conditions in which a business owner can make decisions based on predictable risks, established practices, and accessible resources. During an unprecedented crisis, however, the fundamental assumptions underlying what constitutes ordinary care collapse. Business owners were forced to navigate rapidly changing regulations, all without clear guidance or precedent. To hold them to a standard of ordinary prudence in extraordinary circumstances is to ignore the reality that the ordinary no longer existed. Fairness requires recognizing that decisions made under such extreme and unpredictable conditions cannot be measured by pre-crisis norms. Thank you.
Thank you, Ms. Bijan. And does this conclude the appellant's presentation or any other remarks you'd like to add?
Yes, it concludes mine.
Thank you for the presentation. I would now like to turn it over to the panel members for any questions they may have of either party. And we'll again begin with Administrative Law Judge Kim. Do you have any questions for either party?
I guess I just have one question for appellants. Why didn't the CPA realize that the e-file was rejected?
I think they had some communication issues with the person in their office that was supposed to file do the e-files, and they had some technical issues, and they were just trying to fix it. And at last, it was just on the person who was supposed to finish it up, and it seems like the last attempt didn't go through, and then they just it kind of just they got distracted with the whole issue that they had to move the offices, and they particularly had a lot of technical issues with IT, and they, nobody was there to help them. So basically, they just basically dropped the ball. And but the CPA never realized it until the taxpayer actually got the notices, because she completely thought that it was filed and accepted.
Thank you. No, I don't have any further questions.
And thank you, Judge Kim. Administrative Law Judge Clutter, do you have any questions for either party?
This is Judge Clutter. No questions. Thank you.
Thank you. I just have one follow-up question for appellants. And I just want to go back and again ask about the specific issues related to the filing of the returns. It looks like there were several submissions that were attempted but unsuccessful. Can you provide some detail as to why that occurred and specifically?
There was a glitch in the system because they were just trying to do that, and I mean, that didn't happen with the federal tax returns, but for some reason they had an issue with filing, with e-filing system.
Okay, thank you.
There were a number of problems with technology with the e-filing systems during the COVID-19 pandemic. I mean, this wasn't an isolated instance with a particular CPA. This was part of a larger problem. And, again, I think it's telling that in 20 years, you don't have an issue e-filing the taxpayers' tax returns. It's not like they weren't prepared and filed, and then suddenly during the pandemic, you have an error that caused this. Did the CPA fail in their diligence? Absolutely. Was it reasonable for the taxpayer to follow the same course of action that they always had? Yes, I believe it was. It's different when you're dealing with that. So.
Yeah. Thank you, Mr. Brotman. With that, I believe that we are concluded here. I would like to close the record. Excuse me. I want to thank the parties for their presentations today. The panel of 3 will meet and decide the case based on the arguments and evidence in the record. We will issue an opinion no later than 100 days from today's date. The case is submitted and the record is now closed. This concludes the hearings for the appeal of HRA Highlander LLC and HRA Woodlake Village LLC. And I want to thank everybody for attending and participating. And we have one additional hearing, and that will begin at 3:30.
Thank you, Your Honor.
Thank
Thank
you.
you. Thank you, everybody.
Thank you.